Welcome back. It's time for a case brief with a little bit of a different type of intro because today I am recording an addendum because the court feed cut when the judge decided to place one of the cases on calendar today, the Brian Walshe case, on second call. That's not a last call. It's a we'll come back to this later, but I just wonder amid everything that was going on in court if whoever was operating the camera went, well, I guess we're done for today. So I attended the Zoom hearing for the rest of the hearing on Brian Walshe. So at the end of this case brief, I'm going to add the addendum to tell you about the hearings from court. Because today in court, we had the Brian Walshe case, along with the Myles King case and others, following up from the hearing last week about the federal materials. So let's get into today's coverage. It is spooky season and we are going to court. I think the only one spooked by this hearing is probably former Trooper Proctor because, again, though he won't be in court, he is the subject of the conversation. It's Thursday. It's October 30th. We are going to court for a group of cases that is still dealing with discovery. Oftentimes, the filings are in the Myles King case, which is a homicide case pending trial. The defendant is now out of custody due to extensive discovery delays because of Lally and Proctor. And then there are other cases connected to this, including the Brian Walshe case that was supposed to start trial this month, October 2025, and has been pushed. I think it will probably get pushed again, but we will see. And the issue that they are dealing with is kind of twofold. One, they are dealing with state Proctor discovery. The Commonwealth of Massachusetts grabbed Proctor's new phone and his lawyer was like, haha, he changed his phone. So there's not much there and everything auto deletes on the phone like every 30 days. So good luck, everybody. And then the prosecution was like, okay. And then they downloaded the phone and it went all the way back to 2013 because of the iCloud. So they found, instead of, haha, there's nothing there, they found hundreds of thousands of texts and photos and videos and emails and group chats and more. Oh my. And so the prosecution is now digging through all of that to figure out what is discoverable in any of these 5 cases and possibly more. So there is the Commonwealth Proctor discovery from the personal phone. Then there is the federal discovery from the work phone and possibly the personal phone. It's still kind of unclear, but the federal discovery is what was turned over in the Karen Reed case. Remember, that federal discovery was turned over under protective order from the feds to the Commonwealth. And the Commonwealth was told, hey, you can have this for the Karen Reed case, but you can't tell anyone else about it and can't give it to anybody else. It is under a protective order. But Karen Reed's defense attorneys get it. The prosecutors for this case get it. Nobody else. You can't give it to anybody else. Don't talk about it. We don't talk about Bruno. It doesn't exist. Then, because the case was televised, all the defense attorneys went, excuse me, it seems like there's probably more. We need that. And the Commonwealth is like, excuse me, there's probably discoverable information that we need to give to these defense attorneys, but the federal protective order says we're not allowed to give it to you. But we know it exists. So we're telling you there's discovery that you need, but that we can't give it to you. And they have been back and forth on that at the federal level. And last time we were in court for these cases, the prosecution said to the court, hey, so the feds have allowed us to turn over the discovery that we asked for. So not all of it. Well, the discovery that we asked for. Okay, so not all of it. Well, the discovery that we asked for. Okay, so not all of it. And then the defense was like, well, how can we know if there's not more that we might need? If there's more that, what? And the prosecution said, don't worry. We got a log of all the discovery. So if you think there's more that you need, you can let us know. And oh, by the way, the feds told us under that federal protective order that we needed to either destroy the discovery that we have in our possession or give it back to them by October 31st. And the court said, shit, we're going to need another hearing date. So today is that other hearing date.
My concern, Judge, is I don't want to say I don't have any objections if I'm not going to be able to get the information from the Commonwealth. That's the whole point. The Commonwealth
What information are you talking about? Are you talking about the federal materials or are you talking about other materials?
The materials that are listed as federal materials, which include state grand jury and police reports.
State grand jury is not federal materials. State grand jury is in possession of the DA's office.
Right, I made that.
And that's not being returned. So the question is federal materials. there an issue with respect to the return of the federal materials?
So those state grand jury minutes and the police reports are listed as federal materials, Judge.
What am I missing?
I don't think you have the opportunity to review the index.
The judge is frustrated, clearly, saying, well, state grand jury minutes aren't federal materials. And the defense is saying, well, they're listed in this index that we got of federal materials. So they're listed in the federal material index. And the court's like, excuse me, those are not federal materials. Why are we talking about these things? And do we have any issues with the fact that the DA's office has to return all these materials to the feds tomorrow? And so that's not on the defense. The prosecution is now stepping in, seemingly to also support what the defense is saying and say, well, Your Honor, you haven't had a chance to review the log of what is considered federal materials. So it's on there. I turned it up a bit more.
That's why you're less information than the parties do. So I think the best way to explain it would be that state grand jury minutes, which the Commonwealth produced in discovery to the defendant in Reed, also became federal materials which were reproduced to us. So we have them independently, and if a defendant filed a Rule 14 for state grand jury minutes or for police reports in the Reed case, we would evaluate that because we have those materials in our possession, custody, and control,
Right, so
separate from the federal materials.
Right.
So I agree with the statement that Ms. Capiccio made about the state materials that we have complete control over.
Okay.
I appreciate that the Commonwealth, as the judge was already annoyed, the Commonwealth stood up and said, Your Honor, this is why it's an issue. It's listed here. It's part of the federal materials, but we also have it. So it's not something that has to go back to the feds because it's our materials that the feds have, but it's listed there, and the defense would normally not be entitled to the state grand jury proceedings in a different case. So this is a very unusual situation.
I would ask on behalf of immigration rights, on behalf of Mr. Walshe, that the court order that the Commonwealth maintain a copy of all the documents they have, notwithstanding the order of His Honor Judge Casper.
So the defense tipped in for Walshe is saying, I want the court to order that the prosecution maintain a copy of all of the federal materials and to not adhere to the federal judge's order saying return or destroy them.
All right. Attorney Beatty, before I hear from you, Mr. Tipton, I have a essentially 3-page motion from you. It certainly says that you agree that documents produced to you are favorable to the defense. I didn't read it as saying that it gave you reason to believe that the Commonwealth had other materials that hadn't been produced, which were also favorable to the defense, or even that you might come to a different conclusion than the prosecutors came to with respect to the federal materials. And I don't have an affidavit from you, and I don't have any description of any of the materials, which could be provided to the court under a motion to impound. They could have been sealed, identifying a single document that would fall into that category of favorable to the defense but not produced. So I'm not quite sure how you expect me to grapple with this extraordinarily bare bones affidavit that's not supported with,
How many times has the court said bare bones?
bare bones motion that's not supported by an affidavit.
I swear he said bare bones motion at least 4 times. When the court has said bare bones motion that much, you're on the losing end of whatever is about to happen because the court is like, no, this motion is insufficient.
I will, if the court will accept it, I'll file an affidavit by the close of today, and I'll file it under seal, and I'll lay out what my specific thoughts are based on the review of what's been provided.
Right now, I don't have enough, for sure, to issue an order contrary to Judge Casper's destruction order.
I'd ask that be done within 45 minutes, Your Honor. We have had this date for well over a week. There is an index, which I'm going to ask the court to
Okay, we haven't had this hearing for well over a week. It's been like a week. But the prosecution is saying, Your Honor, if he's going to file more, we need an opportunity to respond. The deadline looms large. Literally, why couldn't this have been done yesterday?
Consider as you're making this decision that Mr. Tipton has, and certainly he could have filed a motion under seal that had more specific information in it, but we do not have time. The Commonwealth has continually been faulted for taking its time. But I would ask that be filed by 3 o'clock. I will wait, and then we can have further hearings on this today.
No. What?
Mr. Tipton,
Yes, Your Honor.
did you hear what Attorney Beatty was just just saying?
Yes, I did.
Okay. Can you file something today?
I certainly can.
Okay.
But I heard her say 3 o'clock,
What?
and I will do everything I can to get it filed by 3 o'clock.
We'll put this on for a second call.
This hearing started at 2 p.m. Eastern. She's like, file that affidavit by 3 p.m. Eastern, and we'll put this on second call, meaning we'll come back to it. Not much happened today in court other than new dates were set in some of the cases because the court feed cut before they finished dealing with the Walshe case, which was put on second call, meaning I will call this case again later, but I also understand that there was a lot happening in court and then all the in-person defense attorneys left and the DA left because they're coming back. And so I understand that there might be some confusion on the part of those sitting in the media saying, wait, aren't we done? No, court's not done for the Walshe case. It's done for the other cases today. But what happened today? So today, they were in court on the Myles King case, the Johnson case, the Walshe case, and the other cases all together to deal with the federal discovery from the Karen Reed case. There is a return or destroy date for the Commonwealth, October 31st. That date is set by court order by the federal judge. That means that the Commonwealth of Massachusetts has to give the feds back the federal discovery from the Karen Reed case tomorrow. The attorney for Brian Walshe said in his bare bones motion, as the court said 4 times, Your Honor, I am concerned. If this is destroyed down the road, we can't even review it to see if everything exculpatory was turned over. We have no way to access it. The defense will be prejudiced by it. And we are asking the court to issue an order that the Commonwealth maintain a copy of all of this federal discovery because the Commonwealth has turned over information to us that is beneficial to the defense. So in argument before the court, the attorney for Brian Walshe said, I believe that the information given to us indicates that there is other information out there that may also be beneficial to us. So exculpatory or potentially exculpatory information, but at minimum, beneficial to the defense. And the judge said, well, that's not in your written motion and there's no affidavit. But the affidavit would have to be under seal because all the federal information is under seal. So the attorney can't say in open court, well, they gave us this, and specify those things and talk about what they said because it's still under seal. So what the defense attorney said is, I will file an affidavit with the court by the end of day. And the Commonwealth said, we need to respond to it. The end of day is too far. Can we do it by 3 p.m. so we can just address it today? And then we can have further hearing on it today. And the court said yes. And the defense said, I'll do my best. I'll do my best to get that in by 3 p.m. So the court said, I need more information because the state level court is in the position where the Commonwealth said there was exculpatory information or potentially exculpatory information that we need to give to the defense. And the federal court order said we can give these things, not those things, and those things have to be returned to the feds or destroyed tomorrow. So there is a federal court order that potentially conflicts with what needs to happen in the state prosecutions. And if you're sitting there going, I don't even understand how any of this is happening, This all sounds strange, right? Because the fact that there was a federal investigation going on at the same time there were state level prosecutions is an incredibly unusual circumstance. And Proctor had his hands in all of these cases because the homicide unit for Norfolk is fairly small, and these are all other Norfolk homicide cases. So it is the same set of troopers and former trooper that are involved. So of course the defense attorneys are like, excuse me, can we not destroy all of it? That seems like a problem. So the judge in court in the Commonwealth, Krupp, is saying, I need more information if you're asking me to file an order that orders the Commonwealth to essentially ignore the federal order. So we are having a whole battle over, well, which court's order is going to take supremacy from one to the other. And the defense attorneys are saying, yeah, I don't care about the feds. I need this information from my client. The feds are saying, we're not going to give it to you. This is not your case. So the fight over discovery for the federal discovery continues. The state level discovery won't be as difficult. Proctor's personal phone and all the other state level information. There will be some of a court order needed to give more Karen Read materials to these defense attorneys. Generally, a defense attorney in like the Brian Walshe case is not going to get the grand jury proceedings from the Karen Read case and probably still won't get all of them. But as to the troopers that are involved in both cases, the defense is making the argument, we need those materials because they are so interconnected to everything else. What happens from here? The other cases are going to be back in December. So December 4th, the other cases will be there. None of the other defense attorneys said that they object to the Commonwealth returning the materials tomorrow. The defense attorney for King and Johnson said, I just want to make sure that the items listed in the index from the federal materials, the state grand jury transcript, and the Commonwealth level police reports, I want to make sure that those things do not get returned. And the court said, those are in the possession of the Commonwealth. That's not a problem. And she said, okay, if that's not a problem, then that's fine. Now it's time for a breakdown. So after the court feed cut, I attended the Zoom hearing for the rest of the Brian Walshe case hearing. And at the end of that hearing, the judge actually made an order to preserve. The prosecution made clear that though there is a return or destroy, not a seek and destroy order, a return or destroy order on the materials, that they are going to return all of the materials they have to the feds. They are not destroying them. The court said, great, then you can include my order to preserve to the feds with all the discovery that you're returning. And the court said to the prosecutor, I am making an order to preserve all of this information. So anything that the feds turned over from the federal grand jury in the Karen Read case given to the Commonwealth is being given back to the feds with the order to not destroy it in case it's needed later. But we also learned a bit more about this from the argument that happened, and Attorney Tipton was very careful to not put things on the record in public court that are under seal. But we learned that some of the things he was interested in preserving, because that is what he asked for, he said to the court, I'm not saying any of this needs to get turned over to me. I'm concerned because we haven't gone through all of the information that we have yet, that if we get through all the information that's been turned over and then there might be something else the feds have and now it's gone, I'm concerned about that scenario. And the court addressed that in his order. But what Tipton also talked about was the way that Trooper Proctor testified in the federal grand jury. And he was tiptoeing around not putting too much info on the record, but did say, shocks no one, that Trooper Proctor was evasive in his answers at the federal grand jury regarding the, and this is the attorney's words, not mine, the inadequacy of his investigation in the Read case. Tipton said the U.S. attorneys had to ask Proctor over and over again the same questions because he was evasive, and he categorized Proctor's answers as, quote, running away from the way he did this investigation, which is so funny because in the 2020 episode, Proctor said, no, I wouldn't do anything different. Well, It seems that under questioning from the U.S. Attorney's Office, maybe he thought differently. The court indicated the thing he was concerned about was if there were materials in the federal grand jury proceedings or investigation that indicated that prosecutors knew that Trooper Proctor's investigation was inadequate. And if supervisors knew, then that information would need to be turned over to the defense. The Commonwealth agreed that that type of information would need to be turned over and said that that type of information did not exist in the federal grand jury materials. We also heard the prosecution go through lists of different materials saying, Your Honor, there are different ways the defense can get these because some of the things on this list, in fact, it seems many of the things on the list are things that are from the Commonwealth investigation. And that those things were materials from the Commonwealth investigation, police reports, the medical examiner's reports, etc., that went to the feds. And there weren't a lot of things, it seemed from the conversation, that were created by the feds outside of the ARCA report and the transcripts of the grand jury, making it seem even more that what the grand jury was investigating was the investigation. Now, we don't know that for sure. We know that they were investigating the death of John O'Keefe, but it seems high number of materials coming from the investigation from the Commonwealth seems to indicate that they were looking at what was going on with this investigation, which has largely been speculated about, but no one knows because it's all secretive. But it makes sense then that the other defense attorneys weren't asking for more materials because it seems a lot of those materials are things that the Commonwealth can turn over to them from the Karen Reed investigation, and that really the heart of the grand jury materials that the defense is looking for largely are transcripts of any officers that testified from that grand jury, because those are all sealed, and the digital data on Trooper Proctor. And those things have been turned over. So you don't really need the Fed's copy of the Commonwealth's medical examiner report. You can just get it from the Commonwealth. So it does seem that most everything that needs to be turned over has been turned over, and that the court is asking the feds to preserve everything in their file and in their possession, including what the Commonwealth gives back to them. So at the end of the hearing, I feel better than I did when the cameras cut, in that it is much more clear what defense attorney Tipton is looking for. And when he asked that these things be preserved, the court agreed, and that order is being issued today. So now we can move on, hopefully, to the issue of how much information is in Trooper Proctor's personal phone, because it seems like all, and if that's going to delay the Brian Walshe trial, which is set to start at the end of November 2025. The next date in the Brian Walshe case is November 17th. Most of the other cases were set over into early December, so we're just going to have to wait and see. A little bit of a special case brief. It's almost a Emily Show extra episode, but you have the Law Nerd app, so you know what we're covering either way. Thanks for being here. Thanks for being a Law Nerd. It was great to see you on the live. If you missed the live, I hope that this summary was helpful. If it was, let me know down below in the comments, and I will see you in the next episode of The Emily Show and in more case briefs. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.